Thank you so much. The project called Rights on the Move, which is the object of today's meeting, has been funded by the European Commission thanks to the program of fundamental rights of the European Union. This program has been going on for a long time, and this project will cover a range of 2 years' time. So it will end at the end of 2014. What is the object of this project? To make everybody aware on different same-sex families at the European Union level. For a long time, the legal framework and the juridical debates have been focused on meetings, on the horizontal relationships. So the marriage issue, the marriage-related issues, which is still at the forefront, the union of the civil partnership or registered partnerships, and the different studies on this juridical profile have been manifold. We have so many studies, comparative studies, on how the different ideas of civil partnerships are taken care and carried out. Of course, we have the comparative law and how these unions are recognized in different countries. But something is lacking today, the role of children. The role of children coming out of these relationships. Children can be engendered outside wedlock, like straight unions, which are treated in a different way from the legal point of view, and the possibility to protect the couple. In the heart of this Rights on the Move project, there are rainbow families where the union between two people can give rise to the extension of a family with children. What is the role of these children? If discrimination is still something which is drawing attention due to the principles of the regulations, but when these children are victims of discrimination, this is even more striking. The lack of recognition of a marriage, of a union, and the state doesn't recognize their rights, or they don't allow their rights, for example. There are different reactions when we are facing a different scenario where people underage have no parents, according to the state. The state doesn't recognize these couples because maybe they are gay couples. So there is no parental protection. And this is a bit of a tragedy. From the juridical viewpoint, there are a number of issues relating the protection of this union. So the protection of these children and the protection of the grown-ups, of the adult people, is rather different. Children must be protected. In the last decades, the protection of children has been hitting the headlines. So somehow there is a disruptive force here, especially when regulations are against this type of families. This is a disruptive force, especially whenever we try to remove all the obstacles, specifically families that went abroad. Nowadays, we have the examples and the evidence of rainbow families and NELFA. We have a part, a dialogue and help to be given to these families. There is a dialogue between the juridical science, the academy, and the recipients of this study. within these partners of the project, there is an association which is Cara Friend, which is represented here by the presence of Barry Fitzpatrick. And then there are some individuals that championed this project since the beginning. These advocates of the project are ranging from the European Confederation of Trade Unions up to the Council of Europe, which after an important recommendations of 2010 set up a forum on these rights of these LGBT people. Even specific experts are dealing with sexual orientations, but also NELFA, which is the European Association for the Protection of Rainbow Families. So they will be the representatives of this association to take the floor later on. One of the profiles will be touched upon here lies in the project of their rights. This is a crucial matter. As you can perceive, from the statistical viewpoint, all these families are more exposed to mobility. These people have to go abroad in order to find those rights that are denied in Italy. And we have also families that prefer to spend their life outside Italy, outside other states. But sometimes they want to go back to their country. So these families are building up their parenthood, so to speak, abroad. But then they go back to Italy, to their country, after maybe the birth of their children. So that's why the European Union is the main cut whenever we are talking about mobility of these parents. Well, we are interested in the competence of these families. But we should reflect on the relationship between the protection of freedom, the free circulation, and the family rights of the 28 European countries. There are so many points of frictions, and we have the evidence and the witness of all these representatives of the rainbow families. Discrimination on work, which is the common thread of this conference, and the working environment has so many similarities and points of contact with the rights, the family rights. So we are not acknowledging a series of rights to workers. That's why the European Union, which is not exactly setting up a regulation or a code, European Union should avoid the creation of obstacles. The fact of not being the recipients on a daily basis of the rights of other families is a huge hindrance in their lives. So how can we tackle this problem? First of all, we should compare the situation of the 28 states. We would like to better understand how each and every state can react vis-à-vis this mobility of families. Secondly, we should question on the legislation, the courts of justice, and we should make a remarkable effort. We should better understand how can we tackle and further this the legal framework. So the Italian lawmaker somehow has been brought to a stalemate. But of course, the legal framework should give some answers. We should better understand how the countries can be channeled into these issues. We should better understand how the body of laws can be enforced And when we are talking about European laws, we are embracing the Human Rights Convention, which can really act upon on these family rights much more than the Luxembourg Court of Justice. In recent years, the European Court of Justice has recognized the rights of being family. They are families. There were important statements made on the right to become a parent, to aspire to be a parent, to be a parent of adopted children, for instance. And the principle we can perceive from this law, from this body of laws, all these people cannot be discriminated due to the fact, on the grounds of being lesbians or gay or homosexuals. So this principle can mitigate so many obstacles which are in among the states. The Court of Cassation, a month ago, the Italian Court of Cassation said that there is no longer a problem of public order when we talk about a gay marriage. The Italian Court of Cassation should apply these principles also in the case of parenthood. I don't see why in Italy we shouldn't accept the idea that we might have two mothers. When Austria has been condemned by the European Convention of Human Rights. So sometimes there were condemnations in Austria. There were examples of petitions denied. In Austria, there is no form whatsoever envisaged by the lawmaker of single parenthood. So in Austria, there was no assumption whatsoever of this same-sex parenthood. So in Austria, there was a condemnation in that sense. If the partner of the biological mother, being a man, could have been requiring the adoption, but whenever the partner is the same sex of belongs to the same sex of the other parent, Austria was brought to a stalemate. So that's why we see that the European data are quite disruptive in terms of family rights and related issues. Well, how all this situation is affecting and biasing the working rights, the labor rights, where this is exactly the object of our debate today. Well, but when we are facing a state that is not recognizing the rights of the worker, in the case of being recognized as a parent, and if we think of the importance of the role of the parenthood and the protection of the worker as a parent, we easily appreciate that the points of contact, the similarities are so many. And whenever we touch upon the labor rights, the European Union is absolutely key in implementing all these rights. So we have been studying so many rulings relating unions. For instance, in Germany was at the origin of so many cases ruled by the Court of Strasbourg, because Germany wasn't extended these rights to civil partnerships. And all these benefits, all these rights were somehow related to the worker and to the retribution of the worker. The Court of Justice expressed itself very clearly. Law should extend all these rights to spouses, but also as well as civil partnerships. So the two institutions should be compared. 95% of the marriage rights are envisaged in Germany. And so whenever there is a denial of the marriage, there is an homogeneous scenario. So the two situations can be compared. And there should be an assumption of no discrimination and equality between the two. This is a huge step forward. Also, what we are experiencing nowadays, we are experiencing a human right which is somehow jeopardizing the marriage institution. The marriage institution has been considered a stronghold. If the Court of Justice of the European Union can dare to say that the marriage and civil partnerships are part of the same family, the same category, any difference in treatment between the marriage and the civil partnership should be equalized, and that should be treated at the same level, so unless there is a specific justification. So in Strasbourg, the marriage, which is referring to the Article 12 of the Convention, is a stronghold which is still legitimizing the equality of treatment. The marriage is protected by the Article 12 and is still considered quite different from the de facto partnerships. And so it's referring to the Article 8, which considers the people living together. There was a ruling in Greece, for example, by allowing the adoption only to legitimate marriages, like in Italy, and how they are legitimized to be in this union. Sometimes we can envisage some justifications, but the novelty of recent years, according to the European Convention of Human Rights, if we make a comparison between a straight couple which is not married, either living together or in a civil partnership or in a living together union, which following the style of Greece, which is a registered partnership, but is only reserved to straight couples. Well, we have the same level here of the same-sex couple which didn't marry, either being living together or within a civil partnership. So if we still think of the stronghold of the marriage, there is a request of equality. In case of a disparity, in that case, it should be justified. So in this case, there is a recognition. So you should justify the lack of recognition somehow and the disparity of treatment. So there are a few cases where there was a justification of inequality of treatment. So we are now talking about the ruling of June 2010, which was then extended to same-sex families. We are also considering the vertical dimension of the family, the parenthood, which is in the eyes of the Court of Strasbourg, the same-sex families, in principle, cannot be discriminated, cannot be an object of discrimination. What are the implications of all this? If I can recognize the parenthood of a civil partnership, I can also recognize the same-sex relationships coming from another state, because I cannot apply a discrimination on the grounds of sexual orientation. There is a child who is subject to this discrimination. When the German court acted upon on the adoption, There were different types of adoptions. In Germany, a single parent can adopt, but if this single parent marries, only in this case, his or her spouse can adopt the son or the daughter of the other partner. But Germany didn't allow this possibility to same-sex couples. So the spouse couldn't adopt the child. So, but there was an assumption of adoption when the child was the biological child. In that case, the adoption was allowed. So, Germany, in its court of justice, they say there is a discrimination of the minor. So there is a body of law which is against France, against discrimination to which children born out of the wedlock are considered. These children were unlawful, illegitimate, and then consequently they were natural children. And the Court of Justice in Strasbourg has chastised and penalized France due to this lack of rights. So the key principles of the famous ruling against France, which was stating children cannot be responsible for the behaviors of their parents. The fact that there was a relationship which was out of the gridlock, or maybe the same sex, cannot be, the children cannot be deemed to be responsible and liable for this. Children of these same-sex couples are following legal reasoning. This is the disruptive force. Minors must be protected because somehow children are paying the price, are paying the damage of a lack of recognition of parenthood, which dates back to the sexual orientations of their parents. So we are wondering here how much this body of law, which states that the minor cannot be discriminated, can we apply it in this framework? The German court, which is one of the most serious, ruled that there is a discrimination against minors. The child of a straight couple can be adopted, even if the wife or the spouse has already adopted that child. In a civil partnership, that child won't ever have the possibility to be adopted. So de facto, it doesn't enjoy the same rights. So this child is subject to discrimination due to the type of relationship of their parents. So this family dimension sheds a new light. I'm not referring only to adults, but also the children, the minors. Minors who are the main recipients of all the protection of workers that is quite well known at a national and European level. In order to stress the possibility of extension of these civil partnerships, we wanted to make everybody aware and specifically train some legal expert. In Ljubljana, a training course will be organized, which will be addressed to jurists, magistrates. In 2 days training, they will receive all sort of information and all the progress report, if you like, and they will be the advocates of a training activity at a national level in their own countries. We want to disseminate a new interpretation of rights in order to recover protection instruments for these families. We will try to give some inputs to European Union on the possibilities, what we can do. We don't want to be rhetoric on the roles of European Union. We don't want to be pushing European Union to be something that is not. It wouldn't be right. We are facing here a federal contest. There are some limitations, but there are also some obstacles that should be removed. As you know, the European Union is struggling on the recognition of the different civil partnerships within the Union to recognize the different acts of civil partnerships, and as a consequence, all these same-sex unions will be registered and recognized. But what is the solution? How can the states can decide their own family rights, and the necessity for the European Union to remove all these barriers for the free circulation of people in Europe. We will try, thanks to a white paper, to give some indications, to give a framework, a precise framework, according to which, without modifying the treaty, maybe the European Union can act upon it. This white paper, together with a handout on the juridical protections, will be submitted in Belfast, June the 4th and the 5th in Belfast, to be precise. I hope you will be there. And the academic results, all the different studies and analysis on the same-sex parenthood will be submitted to Trento on October of 2015. Trento is the venue of the university which promoted this project. There is another project which refers to the transparenthood. This is a totally unknown subject, which is acquiring a new light, not only for the dissemination of the new fertilization techniques, but thanks to the ruling 161, the sex identity is broadening its topic. I would like to explain it by using colors. In the past, we only had black and white. Nowadays, the gender identity is starting from the white, but then it can reach the black color with different nuances. People nowadays are not in the extreme ends, but they can be in the middle with different nuances. So this is the new range of colors. The important assumption is the sterilization, which is required by many European countries for whoever wants a new assignment by the civil registry, the so-called transitioning. Many states are imposing a permanent incapability of procreation unless people are submitted to very invasive intervention. And also, you cannot have a marriage which in the civil registry are considered to be the same gender. Italy, luckily enough, is taking interesting steps forward in this direction. Probably there will be more families with a transgender parent. not only because this parent future parent can adopt, and this is quite common in many European states, but also because theoretically, in reality, these are just a few cases, but whenever I remove the requirement of sterilization, so with some new medically assisted reproduction or fertilization, so maybe I kept my gametes. So even if I will become to be sterile, somehow I got a possibility to be a parent from genetically viewpoint, because I can access, thanks to the medically assisted reproduction, I can really keep my genetic wealth thanks to these gametes. As you know, all the scholars, whenever they debate or theory, are really entertaining themselves because they start to explore new areas which are so charming for them. And so that's why we are focused on same-sex parenthood, but we can try to assess the different rights for this same-sex parenthood. How can we consider the protection of pregnant women? This is a case in point. Can we talk about the protection of people being pregnant and not only women being pregnant? Can we consider parenthood also in view of male sex? So the motherhood could be extended to a man. So the object of protection is not the mother in herself, but the parenthood, the fact of being pregnant, the pregnancy. Somehow, the scholars are really questioning the traditional viewpoint of rights. There have been rulings acquiring a new light. Whenever the Supreme Court of the United States rules the protection of pregnant women has nothing to do with women protection, we were having some doubts. In reality, there is a different assumption here. So the protection of women has nothing to do with the protection of pregnancy. For example, some women decide to renounce their pregnancy, for example, to maternity in order to make progress in my career, has a different situation. That's why the Supreme Court of the United States said that, ruled that not all women want to be pregnant. And this is the community right, the community law. And the lawmaker intervened there. This type of approach is quite meaningful, said the legislature, and discrimination against pregnant women is defined as direct and indirect discrimination. But this is a choice made by the legislature or the union that wanted to compare this type of discrimination to the sex-grounded discrimination. So, although statistically limited, we have a series of hints, a series of clues, and somehow it prompts us to analyze and delve into the new regulations. Intersexuality is another issue to be tackled here. So the intersex conditions can really raise so much interest from a legal viewpoint. The necessity to classify it as men and women maybe these people that don't want to be classified in being a man or women. There is a German law which was put into force at the beginning of this month, which states that if a child cannot be identified since his birth or her birth as a male or as a female, it's possible to leave to classify it later on. Maybe a person could be in suspense for an entire life. If is the case, how can we identify these persons as a father, as a mother, if there is no indication of the sex in the civil registry? How can we protect this type of parenthood, which is deprived of classification in this dualism? So, in the end, there are a series of reasonings which ranges from the civil law, the international law, family law. So 2 years are not a lot. Is not a lot to analyze all these issues. We won't be able to give precise answers, but we would like to perceive and appreciate the nature of problems of these rainbow families. And there are so many nuances and intersections within the framework of the law. There will be a conference in Trento celebrated in October 2014, but there is also a website which is specified in the brochure of the project. You can register to the newsletter if you like, because the first results of this research will be published under these newsletters. Before giving the floor to the organizers, I would like to organize CGIL for being one of the most active partners, for having accepted the organization of this meeting in Rome. As I told you before, all these problems take their origins in Europe, but thanks to the trade unions, we can really tackle these issues because trade unions are very active, and the role of CGIL and the European Confederation of Trade Unions play a different role, which is so important in this project, exploring new answers to this problem. Thank you so much for this detailed presentation. I think you will have the opportunity to intervene and make some remarks over the day.